Hello and welcome to another edition of CPA by William Buck. I'm Chris Bergen.
I'm Garth O'Connor.
Thanks for joining us. Today we're going to be talking through a case study for the new small business restructuring regime, the new frontier of restructuring for small and medium enterprises.
So to kick things off, Chris, what kind of situations suit the SBR regime?
Well, today we're going to be talking about an experience based on an amalgamation of cases that we've worked on over the last little while. So today we're going to be talking about a hospitality business that was hit hard by lockdowns. In this circumstance, the company has accrued ATO arrears of approximately $500,000. And despite its best efforts, it's been unable to catch up on these arrears. And given the industry it operates in, its other creditors are minimal or paid COD. For this business, the employee entitlements are up to date, except for superannuation, which is 3 months in arrears. And other than the ATO, the business is currently trading profitably. And we're going to assume that the director has provided us details about his or her personal situation, and they have excess funds of about $200,000 that they have available to invest into the business.
So Chris, what is the SBR and what makes it different from other restructuring tools that exist on the market?
Well, we're really excited about the SBR regime because, as is bolded there on the screen, it's a debtor in possession model. The traditional voluntary administration and liquidation models that have been available in Australia for a formal restructure process have not provided the company an opportunity for it to remain in control, for the business and its current directors to remain in control. So the SBR regime provides an opportunity for a small business in financial difficulty to put a viable debt agreement to its creditors that allows the business to continue to operate, the directors to remain in control of their own business, and the business is afforded an opportunity to put a repayment proposal to its creditors that would see the business and the creditors better off than if the company was automatically placed into liquidation. And as you'll see as we go through, the SBR regime, it's a quick, cost-effective solution that allows a business to restore its balance sheet and working capital to a sustainable position for the future. And it also, for directors, offers temporary protection from insolvent trading.
So I thought it'd be useful to take you through a brief history of the genesis of the regime. It is relatively new. Of course, we all know the country entered lockdown in March 2020. From the 25th of March through to the 24th of September, the government moved swiftly to provide relief for financially distressed businesses as a result of these lockdowns. It increased the minimum threshold for creditors issuing statutory demands temporarily to $20,000, and the time frame for companies to respond and deal with those demands was again temporarily extended from 21 days to 6 months. Those initiatives came to an end after September 2020. From then point on, the government went away and thought about how else can we support small businesses that are in distress through no fault of their own, and the SBR process was born from 1 January 2021. It was a slow take-up. The industry approached it with some wariness, but it has been picked up and utilised to save a number of businesses, and is a well-used tool in the market now.
All right, so the eligibility criteria. So this on the screen is the 5 key elements that are required for a business to be able to access the small business restructuring regime. So the company needs to be insolvent or likely to become insolvent. The company's debts need to be under the $1 million threshold. Employee entitlements need to be up to date. And we'll just remember that in a moment in the context of the case study we talked about a few moments ago. The company's tax lodgements need to be up to date, and the directors and the company need not have utilised the small business restructuring regime or the simplified liquidation regime within the last 7 years.
Useful to just touch on a brief overview of the timing and steps involved in the process. We will dig into the detail in future slides. But effectively 5 stages: directors confirming eligibility, moving through to proposal and voting, and then plan is effective and the company is no longer, if approved, no longer subject to the regime. So Chris will now dive into the detail of some of those steps.
All right. Fantastic. Thanks, Garth. So the first step is utilising the regime and checking your eligibility. So a small business restructuring practitioner works with the directors to review and assess a repayment plan that is put to creditors. That plan is compared to a scenario if the company was placed directly into liquidation. And the job of the small business restructuring practitioner is to provide a recommendation to the creditors as to what's in their best interests. As is highlighted earlier, it's really, really important to note that the practitioner does not get involved in the day-to-day operations or trading of the business. So that's a fantastic tool that minimises cost and makes this regime really relatively cheap compared to the alternate methods and more accessible. A couple of practical tips from us based on experience. Stakeholder management. While creditors, might be someone's best friend on a day-to-day business, as long as business is going as usual, as soon as people hear about things like bankruptcy, receivership, liquidation, administration, small business restructuring, creditors can sort of, get conscious of their own position and want to take care of their own self-interest. So stakeholder management is really, really important. Make sure your creditors, your employees, all your key stakeholders, your customers are all informed about what's going on. And the second one on the bottom of the screen there is cash. Cash is king. As I was saying, trade creditors may be supportive in the ordinary course. They may look to take payments on a cash on delivery basis going forward or for the short period while the small business restructuring regime is ongoing. So the impact on those creditors, set out on the screen is the impact on the creditors based on the company entering into an SBR. So secured creditors, so think your bank. Secured creditors cannot enforce their security. They do need to continue to be paid in the ordinary course of business though. Ipso facto clauses. Ipso facto is a right for automatic cancellation of a contract. Those clauses in the ordinary course are not enforceable. There's some nuances around that, but if you get to that issue, it's probably best just speaking to an advisor about what those look like. Unsecured creditors cannot enforce their claims, and owners of property, such as lessors, cannot come and collect their assets. Again, like the secured creditor, they need to continue to be paid in the ordinary course, but they have no automatic right to come and interrupt the company's ongoing business. And for directors personally, there is a stay on enforcement of personal guarantees against the directors during the SBR, except as noted there on the screen, with leave from the court. So how are creditors affected by the plan? Effectively, here on the screen is how the creditors are advised based on the plan and the circumstances we're talking about with our case study today. We're talking about a hospitality business that's otherwise trading profitably. It's paying all its trade creditors on time, they're on COD, and it's just got this bear of $500,000 sitting on its back that it owes to the ATO. So in essence, how we advise the different categories of creditors in a small business restructure is this. For the priority creditors, so employees, they retain their ongoing employment and paid in the ordinary course. Note in the case study for today, there was some outstanding superannuation of 3 months. That would need to be brought up to date and paid in full in order to access the small business restructure. And so long as that was done by the company as a part of the plan or in advance of the plan, then it will be able to be recommended to the employee creditors that the plan is in their best interests. As opposed to if the company was placed into liquidation, it'd likely be a case of where their employment was terminated and they were made redundant. Next, on to the secured creditors, so the bank or other secured creditors in the SBR, they're not affected. They just continue to be paid in the ordinary course. Versus in liquidation, there is a realisation of their security, and there may be a potential shortfall to them. And then they also might, for the sake of the directors, they might also look to call upon their personal guarantees. Unsecured creditors, you'll see shortly, get some certainty in a small business restructure. The proposal is put to creditors to say, here's how much money you're going to get, and here's when you're going to get it. If the alternate plan the alternate option or the ultimate plan to the small business restructure was to put the company into liquidation, there's regularly uncertainty about if and when any money will be paid to the unsecured creditors. So it provides a better outcome and a certain outcome for the unsecured creditors who are the main target in a small business restructure. Almost the number one question we get is about the ATO and how the voting works. So we'll just go through a couple of the key items that the ATO has advised us about how they look and how they consider SBRs that have been put to them. So first of all is the plan, the small business restructuring plan has to be in line with the legislation. The main element that pops up from time to time there is there has to be an ongoing business. If someone ceased trading a business 2 years ago and they want to try to use the SBR to cut a deal with the ATO doesn't look favourably upon that and will generally vote no. There has to be an ongoing business. The ATO generally likes good, clean corporate citizens as opposed to people who are sort of trying to ram through a deal with the ATO when there's been something going on in the background that the ATO might frown upon. So we're talking about skeletons in the closet. So therefore the ATO is going to want to review related party loan accounts and movements. If a related party over the period preceding a proposed SBR has been paid in full, but the ATO has not been paid in full, the ATO will look upon that very, very poorly and is not likely to look to support the plan. Thirdly, future contributions. The ATO sort of has a risk profile whereby they like certainty. If the contributions to be made to the ATO and the other trade creditors who are participating in the plan is to come from future trading profits, they're going to want to have a detailed look at historic trading and the viability of future trading. So they're going to have a look at the historic performance as well as the future trading forecasts to satisfy themselves that they're happy to take on that risk. And as I've said a couple of times now, transparency, no skeletons in the closet. There's no hiding anything from the ATO in these circumstances.
So Chris, why do we focus so heavily on the ATO? Why drafting a restructuring plan?
Well, the ATO is the major creditor in the majority of small business restructures that have been completed to date since this legislation came into law a couple of years ago. And the ATO is actually, based on the positive engagement that they've had and the fact that they're happy to look at a draft plan and provide feedback, they've actually voted for more than 90% of plans to date. So it's a really, really positive start. And it's a wonderful way to be able to deal with them and to make everyone better off based on the previous slide where everyone's happy to avoid a liquidation and support a good ongoing business that, as we sort of said throughout, has no skeletons in the closet. So voting in an SBR is simple. Quite simply, it requires a simple majority in value of creditors to vote for the plan who are going to participate in the plan. So in the case study we were talking about today, where the trade creditors were essentially paid in full or on COD terms, so long as that 3 months of superannuation is up to date, well then the simple vote in our case study for today is we require the ATO to vote yes, and then we're off to the races and we can go and implement that restructure. Really important to note here, everyone talks about credit ratings as well. Credit ratings are a huge thing these days. Everyone, when you're trying to borrow money, the first thing everyone talks about is, have you been subject to an Optus breach or some other breach? How does my credit rating look? So really important, a liquidation or a voluntary administration traditionally shows up on someone's credit history throughout the entire period it takes to complete that. Whereas the small business restructure, the ASIC notification, the public notification, is only there for a short period of time while the small business restructuring plan is being worked upon and put to creditors. And once it's voted upon and put into effect, that public notification automatically falls away, which some people have found beneficial for the sake of their own personal credit rating. So the solution that the small business restructuring regime affords us for our case study today is, assuming that the plan is accepted by the ATO go and receive 25 cents in the dollar via an injection of funds from the directors. As I was just saying, there's no further public notice that the company is subject to any form of external administration. And by the ATO's $500,000 being paid at 25 cents in the dollar, $125,000, some new debt, some new funding comes in from the director, and the improvement to the business's balance sheet is $375,000. And importantly, for all the external advisors out there, the business is able to be ongoing, and therefore we've managed to retain a client. So hopefully these have been glittered in as we've gone through the slides today. So the key tips and key takeaways that we've got for everybody are stakeholder management, keep people informed, always be proactive, especially with creditors, to make sure that they're aware of what's going on in advance. Cash is king. Trade creditors might put the company on on stop supply. They might want COD. Make sure your clients and yourselves are managing your working capital really carefully, and potentially have some options to obtain third-party funding. Ongoing statutory obligations for lodgements and employment entitlements need to be kept up to date throughout the proposal period. Before someone contemplates a small business restructure, it's possibly a good idea to review your history, review the loan accounts with the related parties, review ATO lodgements, and be able to understand and explain anything that's outside of the ordinary course of what the ATO would look at as a good corporate citizen of lodging on time and, where possible, paying everything on time and those sorts of things. And lastly, for businesses that are contemplating paying a dividend under a plan to creditors via future trading, you need to be really realistic with yourself. You need to have a viable plan supported by evidence that shows that your future cash flow is going to be able to spit out enough cash to make those contributions under a plan viable. And there's no point in going through the pain and experience of this exercise if you haven't got something that's realistic. It's not going to stand up to a rigorous review once you get to that stage.
So on the screen now is a bit of a refresher, just a visual representation of the various stages and core steps in each of those stages that take place through the SBR process. So for your reference at a later date, just the main steps in the process. So always useful to recap some of the material and test yourself. So I've got some key questions to put to the audience today. So this is a really key question to always have front of mind. But Chris, what is the threshold debt limit for an SBR?
The threshold debt limit is $1 million, and there's certainly not no limit. The talk in the industry is that this limit might increase, so watch this space as the SBRs continue to develop over time.
Second question. So Chris, who can vote on a plan?
Only creditors who are subject to the plan, those creditors who are going to receive a cents in the dollar dividend, are the ones who are able to vote on the plan. So no employees particularly are not able to vote. They have to continue to be paid in the ordinary course.
Stepping back to an earlier slide, when did the small business restructuring regime start?
Good trick question. We did talk about March 2020. That's when there was some temporary changes to the regulations around statutory demands. But the small business restructuring regime started on the 1st of January 2021.
Another useful question to always have front of mind when talking to clients, but what are the eligibility criteria for an SBR?
Give everyone half a second to look at those on the screen. Yes, employee entitlements need to be paid up to date. Yes, tax lodgements need to be paid up to date. And yes, the company needs to be insolvent or likely to become insolvent. So the answer is all of the above. Well, thank you for taking the time to join us. As always, if you've got any comments or questions once you've gone through the slides, please feel free to touch base with us. And thanks again for tuning into another session of CPE by William Buck. Thanks. Have a good day.